All right, welcome to this explainer. Normally, reading through dense legal text is a guaranteed way to put yourself right to sleep. But today, we're going to take that dry text and transform it into something genuinely fascinating. We are breaking down the South African Marriages Act of 1961. So, instead of just reading you a bunch of legal jargon, we're going to use the actual source text to build a step-by-step guidebook. I want you to imagine you're tying the knot in that exact era. What did you actually have to do? Who did you have to talk to? And what strict, rigorous rules did you have to follow before you could finally say, I do?
Okay, let's dive into this highly structured journey. We're going to be looking at number 1, the marriage officers. Number 2, the intense paperwork like bans and licenses. 3, rules for minors. 4, prohibited relationships. And finally, number 5, the actual ceremony rules.
So, Section 1, the marriage officers. Finding the right person.
Your very first hurdle as a 1961 couple is just finding the right person to legally marry you. Section 2 of the Act explicitly lays out these different classes of officials who hold what they called ex officio authority. Basically, this means they had the sheer power to marry people simply by virtue of holding a specific government office. Depending on your status and exactly where you lived, you'd need to track down one of these specific officials. It could be a magistrate, a special justice of the peace, or a native commissioner. Now, what's really crucial to note from the historical text here is that the Minister of the Interior held the power to designate these authorities with very specific limitations. An official, or even a minister of religion, might only be authorized to solemnize marriages within a specified area, for a set time, or, reflecting the laws of the era, only between persons belonging to a specified race.
And you really had to make sure the person standing at the altar was completely legit. Section 11 of the Act strictly mandated a massive penalty for anyone faking it. If someone purported to solemnize a marriage without the proper legal authorization, they were guilty of an offense liable to a fine of up to 400 rand, which, by the way, was a huge sum in 1961, or they could face up to 12 months in prison. The state absolutely did not take fake weddings lightly.
Moving on to Section 2, bans and licenses. Or, as I like to call it, the mountain of paperwork.
Okay, so you've found your marriage officer. Awesome. But now comes a seriously intense level of public bureaucracy. Before you even thought about walking down the aisle, couples usually had to deal with the publication of bans. This is a process rooted in deep tradition. Essentially, it was a public broadcast of your intentions, specifically designed to give literally anyone in the community a chance to step forward and raise a legal objection to your union.
So you basically had 2 choices here. You could take the standard, super time-consuming route of publishing your bans, or, if you were in a rush, you could apply for an expedited special marriage license. But that fast-track shortcut required paying a prescribed fee and submitting yourself to a much more rigorous legal process involving sworn affidavits.
Let's look at the standard process and see how this builds. If you went with the bans, it was a multi-week waiting game. First, you submit a written application with your signatures, your ages, marital statuses, and residential addresses. Then, get this, the minister of religion literally reads your personal details out loud to the entire congregation during a public service for 3 successive Sundays. Or, alternatively, they could post the notice in a highly conspicuous place at the church for that same unbroken 3-week period. And once that was finally done, the bans were only valid for exactly 3 months. If you missed that window, you had to start the whole shebang all over again. But what if you absolutely couldn't wait 3 weeks? Well, if you opted for the special license to bypass the waiting period, you came face to face with Section 19. The issuing officer was legally mandated to interrogate you. If they even suspected any lawful impediment to the marriage, they would administer an oath or require an affirmation and question you directly. Only after signing a prescribed affidavit swearing there was 0 legal roadblocks would you actually get your license.
All right, Section 3, rules for minors. Are you actually old enough?
So you've got your paperwork sorted, but according to the state, in 1961, are you legally old enough to even be doing this? The law drew a stark, definitive line between genders regarding minimum ages. Section 26 made it completely impossible for boys under 18 and girls under 16 to marry without explicit, written permission coming directly from the Minister of the Interior. And the text even notes that the minister would only grant this if he considered such a marriage desirable. Plus, even with that high-level permission, you still had to go and get all the standard parental consents anyway.
The crucial point here is the massive paper trail of consent. If a minor was over those absolute minimums but still under 21, they needed consent from their parents or legal guardians.
If a parent was deceased or absent, a commissioner of child welfare could step in, but only after a proper inquiry to ensure it was in the minor's best interest. They could even force them into a prenuptial contract if they thought it was necessary. And what if a parent just stubbornly refused to give consent? The minor could actually escalate the matter all the way to a judge of the Supreme Court. The judge could literally overrule the parents if their refusal was deemed without adequate reason.
On to Section 4, Prohibited Relationships. Time to check the family tree.
Assuming age wasn't an issue at all, the Act then forced couples to navigate these incredibly specific legal restrictions surrounding their family trees. Now, it might sound like a strange, maybe slightly dramatic question to us today, but Section 28 of the Act actually spends a significant amount of text answering this exact scenario. Could you legally marry your in-laws? While the Act explicitly carved out protections for these very specific relationships, for example, a widower was perfectly within his legal rights to marry his deceased wife's sister. A widow could marry her late husband's brother. It even extended to divorce. You could legally marry the sibling of the person you just divorced. The major catch, as stated in the text, was the rule of affinity. You could marry these in-laws provided they were not a direct ancestor or a direct descendant of your former spouse.
And finally, Section 5, the ceremony rules, the strict rules for the big day itself. You've jumped through the bureaucratic hoops, you've proven your age, and you've cleared the family tree. But even on the actual wedding day, the state still had strict rules for you. According to Section 29, you couldn't just get married wherever and whenever you felt like it. Marriage officers were literally not obliged to solemnize a marriage outside the standard working hours of 8 in the morning to 4 in the afternoon. Furthermore, the venue was heavily regulated. It had to be a church, a public office, or a private dwelling house, and it absolutely had to be done with open doors. Closed-door, secretive weddings? Explicitly forbidden to ensure the total public nature of the contract.
The source text is also crystal clear on another mandate. It required the physical presence of the parties and at least 2 competent witnesses. The law stated, and I quote, "No person shall be capable of contracting a valid marriage through any other person acting as his representative." So this completely outlawed marriage by proxy. No dialing it in. You had to physically be in the room.
And this brings us right to the climax of the procedure in Section 30. If a religious minister was marrying you, sure, they could use their usual church rites. But if you were being married by any other non-religious marriage officer, like a magistrate, they were legally forced to recite this exact mandatory script. It wasn't about romance. It was a verbal legal contract confirming, once again in front of everyone, that there were absolutely no lawful impediments.
So, only after you answered that exact legal question in the affirmative and only after the two of you physically gave each other your right hand could the officer finally recite the closing formula, "I declare that A, B, and C, D here present have been lawfully married." That handshake and those highly specific words were the final keys to completing the bureaucracy.
Which leaves us with a really fascinating thought. We've just walked through an incredible maze of 1961 paperwork, age restrictions, designated officers, and exact legal phrasing. But when you strip away the romance, the flowers, the cake, marriage remains fundamentally a contract with the state. So how much of this mechanical, rigid bureaucracy from decades past do you think still invisibly shapes our modern lives and the entire institution of marriage today? It's definitely something to think about the next time you see someone walk down the aisle. Thanks so much for joining me on this explainer, and as always, keep learning.